Happy holidays, IP friends! Welcome back to IP Series with Rita. Now, if this is your first time listening to me talk about everything intellectual property from copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication, please subscribe or favorite my podcast, like and share with your friends. And if you're yet to check out the previous episode on how to register a trademark in Nigeria, please head your listen to it and also share. If you're a business person, you're a creative, you own an SME, you're a startup, please share with your loved ones. Now, for my returning listeners, you guys already know the drill. Thank you so much for coming back as always. Really excited, and I'm grateful to everyone that also participated in the just concluded IP Series Christmas games. I didn't expect that engagement, but you guys blew my mind. So congrats again to the winners, Chioma, Amarachi, and James. Now let's get into our conversation for today. Now, per tradition, I always do at the end of every year, I list out my top IP cases and trends and development that have taken place globally, not just in Nigeria. So I started this in 2019, and this is the 4th edition. And for this year, I decided to try something different as well. I decided to do a giveaway. Although I've done giveaways, not giveaways, but yeah, I think I've done one before. It didn't really go well, but this one rather blew my mind. So let's get into my top cases or highlight for the year. The first one is the Odogwu Bitters case, which I came across on my Lawyer Way Sabi Instagram page. When I saw it, I was like, oh! And then I did a Google search and I didn't see anything. I was like, oh my god, how did she get this information? So it was really mind blowing, because I know when Odogwu Bitters came out, there were a lot of publicity, PR, endorsement deals, ambassador deals going on. And I think this is the second time I'm going to talk about Big Kubana on my podcast. I think the previous one was, this is the third time actually. Why is that? I don't know. But yeah, the first one was about I think there was something that they used. Obi Kubana restaurant. I think I talked a little bit about that last year. Then the second one, yeah, this same Odogwu issue where Banaba was like, Obi Kubana is supposed to pay me something for this Odogwu. And I think it was my friend Reginald Walker that drew my attention to it, and we had a brief discussion, and I decided to do a short video about that, so you guys can check that one out. But this particular story, a lot of things were going through my mind when I came across this case. And so the story goes like this: that Obi Kubana has lost the intellectual property right to use Odogwu Bitters as his trademark because someone already registered Odogwu Bitters. And I was like, so fast. I know we do apply the first to file principle, but how was that person so quick? How long is it taking? 2 years, 3 years to get that done? Did he see the future? So, as usual, when I saw that, I decided to, just scribble down a couple of things as to what business owners, especially SMEs and startups, need to know when it comes to locking down a particular trademark in the relevant class. It also turns out that his NAFDAC number or registration has been revoked, and we know that when you're doing your NAFDAC registration, you also need your trademark registration certificate as well. Sometimes you're required to show your acceptance or acknowledgement letter just for you to commence your applications. But yeah, let's focus on the main thing. I already established the fact that in Nigeria we apply the first to file principle, meaning that if I go and file the application for Odogwu Bitters in the relevant class, I get to be acknowledged as the trademark owner in Nigeria. And what happens again, that in the course of doing your trademark registration, even when you get your acknowledgement and your acceptance, when you get to the opposition stage, if I am the first person that registered it, I can oppose, or I will, or mandatory that I should oppose your registration, basically. So I just want to start from why it's important that you do a search, what business owners need to know going forward, how can they avoid all of these. So first up on my list was, first, talk to a licensed trademark agent, or at best hire a law firm, or if you know any intellectual property lawyer or trademark attorney, someone that focuses more on trademark, you can reach out to them to assist you with your registration. That's the basic thing. Now the next thing is that you can do yourself ahead is to do a Google search, which is very easy to do. You do a Google search to confirm whether the name is available in Nigeria. If someone is using it for something, that gives you an idea as to the next step to take. Then when you discuss with your trademark agent, two things might happen. They might want to commence your registration by doing a search, or they might get the try to get what is called a preliminary advice from the trademark registrar rather. So let me explain that further. So if you decide that you're going to do a letter to the trademark registrar asking for their advice, basically you're going to be asking them whether the mark, be it a name, word, logo, slogan, symbol, or sign, that's for conventional trademark applications. Now for non-conventional applications, you'll be talking about smell, smell, motion, holograms, etc. Now you're basically asking the registrar to tell you whether your mark is distinctive enough or is unique enough, because one of the basic requirements for a trademark is that it must be distinctive and used in relation to the class that you want as it relates to your goods or services, if it's what you're going to do. One thing that most people do not know is that when you do that and you go ahead to apply, let's say your application was rejected because it wasn't distinctive enough, you are entitled to a refund of any fee that you had paid in respect of that application, as long as your application was submitted within a period of 3 months after you have received that confirmation from the registrar as to whether your mark is distinctive or not. You can also file a notice of withdrawal before you are entitled to a refund of the fees that you had paid. So if you hire a law firm versed in trademark, or an IP lawyer that's versed in trademark, you see that I'm focusing more on the lawyers and the law firm, not because I'm a lawyer, but because it's the right thing to do. You have good agents and you had bad agents out there, but a lawyer will not trick you, and neither would a law firm trick you, because one, we have fiduciary duties to our clients, but I'm just going to stick to that. So if you really want to learn more as to getting preliminary advice from a trademark registrar, read section 17 of the Trademark Act. That's the Nigerian Trademark Act. But yeah, let's talk about doing a trademark search then. Now, take note that preliminary advice is not mandatory, but just to save you from other things, it's advisable that you either opt for that or opt for a traditional trademark search at the registry, which helps you determine whether your trademark is capable of being used for commercial purpose. You know that IP generally encourages that whatever intellectual property that you create be used for commercial purpose. It helps you also determine whether it is distinctive enough, whether it is good for your company brand and name. It also helps you determine whether you can use the mark that you've selected in the right class. And also, it's like when you're doing your corporate affairs, your company registration, you know whether the mark in question is available. So you might be advised that it's not mandatory, but it's very mandatory, because you definitely at the end of the day get a response from the trademark registry. And the trademark registry also makes provision for that. If they did not want parties to actually apply for search, I'm not sure that they've included that for the whole process, whether the online portal or doing it manually. Now, where in an instance where you have, say, a device, a word mark or a design mark, which is considered to be a device mark, you will be expected to do two separate trademark search. Um, timeline for doing a search. You have to do your search before you commence the official trademark application. Do you do a full search or a preliminary search? I think it all depends on what you really want. There's no yes or no answer. It also helps you avoid and trade names that are already registered or used for commercial purpose. So I guess I'll just stop here for now. But know that conducting a trademark search in Nigeria um would save you a lot. I believe that if Obi Kubana's lawyer had, or the agent had done the needful, they would have avoided what had just happened to them, because the trademark registry allows um, applicants to pay for searches, um, but this search is always done manually and physically at Abuja. Sometimes when you're doing your search, you get things or comments like identical trademark, which helps you identify whether they are visually or phonetically identical. Similar trademark, whether your trademark is similar or confusingly similar or identical to another existing mark. Then I think that's I'm just going to stop here so I don't give out so much. But yeah, let's just move on as to lessons that businesses can learn from this Obi Kubana's case. Now, next up is that you need to get your IP documentation right by registering your intellectual property so that you enjoy the full backing of the law. Remember that IP is territorial in nature, so it's only the countries that you register your mark that you are protected. If you don't register, you can't claim that you own it. It's gonna cost you a lot or be a bit complicated, but it's best that you do it right. You also need to know the difference or the benefits of doing a corporate registration, as doing a registration at the Corporate Affairs Commission, and doing a trademark registration. Now, for Corporate Affairs Commission, it depends on what you want and is important for new business. So as a new business, you want to let people know that, okay, you have an existing structure or entity, you opt for that. However, when you do a trademark registration, um it shows people that you do have long-term goals for your brand and your company. You also take your intangible assets seriously, and it helps you position yourself and gives you visibility as well. But the downside is that you cannot open a corporate account, whereas for business name or private limited company or public limited companies, you can open a business name. It also helps you build um, confidence with your customers. That is for corporate accounts or corporate. Oh god, that's your corporate name now. Helps build confidence in your customers. Whereas for trademark, it shows that you are working in line with your brand's vision of being a paid setter within that industry that you are working in. Also take advantage of the fact that um trademarks gives you exclusive rights to commercialize your trademark for commercial purpose. You can also monetize it where you get to license it or assign it to a third party to manage for you, etc., etc. Then this is very important. Acknowledgement or acceptance letter does not stand as a trademark certificate. I've had that issue with clients when they come for consultation, or insisting that they have. Also, I had an instance where someone was like, he had a trademark certificate and I think he had misplaced the one he had, and I asked for proof, and he showed me an acknowledgement or an acceptance. I can't remember now. And I was like, that's not a trademark certificate. Don't make that mistake. Don't think that once you get your acknowledgement, you've gotten a trademark certificate. You've not. You've not even done. You've just crossed, let's say, stage one of the hurdle of doing a registration. You also have the opposition where someone can oppose a registration, and you can, you will not be granted the trademark to that particular name or mark. Then the process of registering a trademark is not the same as trademarking it. So it's like I'm applying to get a trademark. That is the process of you registering your trademark. Trademarking it means you've gotten your certificate. That's it. Then trademark grants you the exclusive right to use your mark within the registered territory, to enforce your rights, to prevent third parties from using your trademark without your consent, permission, and authorization. Anything that falls outside of this is considered to be an infringement of your intellectual property rights. Trademark acts as a source identifier. It also gives you exclusive rights and legal backing to use it for commercial purpose. In order to do that, your mark must be distinctive, which I have stated before that it's very important for brand owners to, consult and have discussions with their lawyer, who would either choose to get a preliminary advice from the trademark registrar, or just up to do a search. Then I carried out a poll on Twitter, though I didn't get much participation, but 50% said they did not think that Odogwu bitters was distinctive enough, or Odogwu itself was distinctive enough and deserved to be protected as intellectual property. The 3% said cultural appropriation. Why? Seriously, guys, when you answer this question, just do me a favor. When you pick your answer, just type, "This is why I chose this answer," so that I get to understand you guys. And I put that there on purpose, because I think if this was the other way around, we would have been screaming cultural appropriation. Someone's trying to monetize a phrase from our mother tongue, etc., etc. But this is done by a Nigerian, and everyone is like acting like they're not seeing what's going on. Let's see. 17% said yes. Odogwu bitters. I mean, I don't know I can't really say if it's distinctive enough. But so far as you can show that you're going to use that mark for commercial purpose, I think it should meet the basic requirement of being distinctive. I mean, it's not a colorful word or a fanciful word, but it's also not what's the word I'm trying to get now? It's not a descriptive mark where when you hear Odogwu, you know that, oh, this is what they are referring to. Then I asked, so like I talked about the Burna Boy saying Obi Kubana had to pay him something. 56% said they did not remember and they were not aware. 44% said yes. And I'm wondering, you guys should please do your Google search and look up that comment when Burna Boy made that statement. And also check out my post about it. Then I asked, who do you think was fast enough to trademark Odogwu bitters? 75% said maybe Burna Boy. I think right now, I think the original owner has to come out and say, I own Odogwu bitters. 25% said, I wonder who. And I'm with 25%. I wonder who was fast enough to do that. So yeah, just check out the previous episode where I talked about, where I did. I had Derek on my podcast for the Christmas edition. Come talk to us about how to register a trademark. So check that particular episode. Now let's move on to highlight number 2. So highlight number 2 would be the Netflix against Barlow and Bill case, where Netflix has sued them for copyright infringements over their unofficial Bridgerton musical. They also were sued for trademark infringement. And it turns out that these ladies had won a Grammy award for the unofficial Bridgerton musical, and it started like play. So they did like a cover on TikTok, and next week was like, oh, wonderful. And then you're like, okay, let's get into the studio. And I think I had to listen to the whole track to understand where Netflix was coming from, and also had to go through the documents that they had filed in court against the duo for, infringement of their intellectual property. I also did an extensive cover, not cover, but I talked extensively about this case in my newsletter. So if you want to know more about it, please check out my newsletter. I think it's episode 14. But sometime in September, parties decided to resolve their disputes. That happened 23rd of September. Netflix decided they're not suing them again. But no, as usual, they'll tell you for an undisclosed terms of settlement, and you're wondering, not you, I'm also wondering, like, what did they actually agree to? Because Netflix at some point had offered to what's the word now, they were going to sponsor them, but they refused. And I understood where they're coming from in terms of ownership when it comes to the song, and all of those things. They did not want to let go of control over ownership of the song. But then Bridgerton is broken down into different types of IP. The original author, which is the person that wrote the book, then Netflix, and then the producer or the director, which is Shonda Rhimes. They also have their own IP as well. But yeah, that's one of the highlights of me. I'm also looking forward to that case because it was going to set a precedent as to how derivative works would be considered. But then parties settled. So out of court settlements is more or less called alternative dispute resolution, and the benefit of that is that it saves you time and costs. I just concluded a mediation where we concluded in less than 3 months. Parties are happy, everyone is happy, and they got paid. But yeah, so you have the mediation, conciliation, arbitration, negotiation. So benefit is that it preserves relationship as well. So instead of going your separate ways, you want to continue working. It's also very confidential and private procedure. It is party driven because of its private nature, and it is neutral to the law, language, and institutional culture of the parties. So parties have a higher percentage when it comes to what happens, how the proceedings will go. Whereas where you're in courts, it's the judge that has the final say, judge that dictates what parties should do, even though parties will make application and try to persuade the judge. So yeah, that's my case number 2. But you guys can check it out and let me know if that also was in your own top IP case. So the newsletter version was like, is it possible for cinematograph works to enjoy some sort of IP protection? Is Bridgerton an original expression eligible for copyright protection? And we know that when it comes to intellectual property, you need a license, you need authorization to do certain things. Can a cinematograph work be adapted into a musical work without the concept? Like you're trying to convert a TV series into a musical concept. You need the consent of all the parties involved in that, even though you're going to be creating a new work. So it was complicated and one of my highlights for the year, but parties settled, which is good. So yeah, let's move on to number 3 for me. Highlight number 3 for me would be the Bangui agreement that covers trademark, industrial design, and trade names entering into force under the OAPI IP season. OAPI is full for Organisation Africaine de la Propriété Intellectuelle. I hope I didn't butcher that, but OAPI consists of Francophone, that's French-speaking countries, and they recently just had this agreement. So that's like one of the highlights for me, and it came into force 2nd of January. Like the year was just starting, just like how we're entering into a new year, and the very next day, this agreement came into force. So that's for that. Then number 4 for me is, Christmas came early for Christian Louboutin. I just looking at the rhymes and I was like, red for red, Christmas red, CL red. CL is like one of, I think it's almost every female's dream brand, especially the pumps, the red stilettos. Hopefully I'm gonna save up for that one day. But yeah, they've been battling Amazon for a while now, trying to hold Amazon accountable for people that sold counterfeited and inauthentic CL brands on their website and on their platform. And like 3 days to Christmas, the courts held or decided. Let me know you held. The court decided that Amazon can now be held liable for the offering for sale of counterfeit distributed, but also distributed by itself, but also for counterfeit also distributed and sold by third parties on its platform. So we know that Amazon and the likes of eBay, you can sell products on that platform. I don't know if that's done on. I think it's done on Jumia, but no one has really put their foot down as to enforcing IP rights, like it's being done. Let me not compare now, but let's just stick to the basics. So it turns out that sometime in 2019, Christian Louboutin had filed a complaint against Amazon at the Luxembourg District Court and at Brussels Companies Court to stop the litigious use of their trademark signature red so in Amazon's commercial communication, to stop the sale of counterfeits despite the numerous warnings. So as an IP owner, you have the right to enforce your intellectual property rights. You have the exclusive right to enforce your rights, prevent third parties from doing things that are only you can do. And counterfeiting is one of the things that I think everyone is battling globally. And this Christmas period, you find out that a lot of counterfeited goods are sold more than any other season because everyone wants to buy gifts. Everyone wants to get something cheap and affordable. They don't care whether it's authentic. And there's no disclaimer that, oh, what you're not getting an original CL or red bottoms, So yeah, I think Christmas came early for, CL, and they were very happy. I came across that post on LinkedIn, and then I saw the council that had represented CL posted it. I was very happy. You know how it's done on LinkedIn? I was like, oh my god. So I just had to follow the council. Can't remember his name right now. But I followed council, and I didn't even know I wasn't following CL on LinkedIn. I was like, oh my god, how did that happen? And I know I've done a previous case. I think it's the Coty Amazon case again, where a counterfeited perfume was sold, and the court was to decide who should be held liable for something like that. So you guys can, I think if you work for an e-commerce platform, you should put these things in line so you protect yourself and your brand and save money from all this litigation that will be springing left, right, center. And I think you also need to work with the agencies in charge of trying to fight counterfeited and pirated goods as well. So that's for number 4. Number 5 is the Lynn Goldsmith against Andy Warhol Foundation. Not foundation as in makeup. Oh gosh. So it's the famous case against about the prince's photograph. It's still in court, and I think a few months ago I listened to the arguments from counsel at the oral hearing, and I had shared my highlights on LinkedIn. Trying to get the date now, but I just shared what I picked out from both counsel regarding the case. Hold on, guys. Let me get you. So I've also been following this case since I analyzed the Nigerian case of Oluwadamilola Banire against NTA Star TV Network Limited. I highlighted a couple of things last year when so I did a post when they had the World Photography Day. Talked about data protection related issue, copyrighted issue, also did a newsletter version, did a podcast version, did a Twitter version. But this particular case was really interesting, and I've been following it. So 2 months ago they had the oral arguments, and this is so the case focused on visual artist's use of another photographer's photos of prints in their work. Now, some of the highlights were what is important under copyright is supposed to encourage creativity, protecting artists' rights to monetize their work. The artist in this instance now would be Lynn Goldsmith. Stretching the concept of a derivative work was the copy of the original needed to best achieve Warhol's purpose. Lessons that creatives can learn that I had highlighted. Know the difference between a transformative work and a derivative work when getting creative. Photographs are eligible works, and this case focused on Prince's pictures that were taken by Lynn Goldsmith, and she had licensed it at some point, but then they went ahead to use it after the license had expired, claiming that they were paying homage to Prince, and for commercial purpose, and also to promote creativity. That's like one of the benefits of IP. Copyright foundation. Copyright violation happens when you choose to incorporate a pre-existing copyrighted work. So you need to be very careful as a creative when you're using a copyrighted work. Creators like to be paid and acknowledged. Pretty sure photographers will agree with me, especially now that you're seeing a lot of takedown notices and photographers demanding that whoever reposts their image must not remove their watermarks. Licensing is a way for creatives to generate revenue. Just like we had the Ihanacho and then Puja Media case. Then I think that basically covered it, but you can check out my post on LinkedIn. I shared a document regarding the highlights of the Warhol Lynn Goldsmith case. Let's see what the court decides in 2023. Number 6 for me would be the Moderna suing Pfizer for patent infringement about the mRNA vaccine technology used in their COVID-19 vaccine. I had talked briefly about this case with Sami Zero Lewa, who is a patent examiner, so you guys can check out that episode. I think it's like it's 2 episodes before this one you're currently listening to. Then that's number 7 now, under the new edition of the next classification, which is the 12th edition, anyone who wants to register virtual goods and that covers the metaverse can do so now in class 9. Sadly, we're still using the 9th edition in Nigeria, but it's not like it's a bad thing. I think we don't want to rush into anything or be cajoled into joining the crowd. I think the registry are doing their groundwork in terms of engaging stakeholders so they make the right decision as to whether or not to adopt this new 12th edition. But it's interesting to see how NFTs and metaverse are just growing and expanding. There are lots of conversation that we previously had pre-COVID, so it's a good thing as well. Then number 8 for me is this year we had the Nigerian IP community in collaboration with the Nigerian Copyright Commission and WIPO, that's the World Intellectual Property Organization Nigeria. They had a 2-day hybrid national IP strategy validation workshop to review the final draft of the national IP policy sometime in September. So you see, we have this policy there, hoping that it's assented to, the president gets to sign it before he japas and leave us with Mr. Metobi. That's my candidate. I'm obedient, please. We need Nigeria to change. But yeah, interesting conversation within those 2 days. I think I had a comment that I had posted then that there was no much emphasis as to geographical indication, even though the conversation we've had a couple of stakeholders meeting regarding promoting our agricultural and non-agricultural products that we have, and so that we don't have people coming to take advantage of this gap. So maybe the feedback will be taken and it will be included, but let's see what the final draft that is assented to would include. But yeah, let's move on to number 9. So I was scrolling through Instagram. Was it this month? Trying to think. Yeah, it was this month, and I came across a post by a footwear maker. He was like, woke up this morning to a lawsuit from the mega giant corporation that I supported my whole life. The fact that they're suing a young black man who started out exactly how they did is kind of crazy. Ironic how they tell us to just do it. KIY ready, dude. What the Key Art Show, 12/3, 2022, Miami. And I was like, IP is not sentimental, guys. If you're infringed, you don't pull up the sentiments or racial cards and all that just to deter people from the fact that you actually copied or you stole someone's work. I mean, so Nike had sued Nick One Abringer and David Weeks of Buy Key LLC, aka Cool Key, and Bill Omar Carrasquillo of Reloaded Merch LLC, also known as Omi in a Hellcat, for trademark infringement, false designation of origin, unfair competition, and trademark dilution over their Air Jordan 1 and Dunk. Nike was also asking the court to block any further production and advertisement of the infringing sneakers and not product packaging and promotion. And I was like, promotional materials are sent, that they should send out promotional materials to Nike for destruction. And I was like, okay, this is really interesting. I was going to do a Twitter version, but I was like, nah, let me save the best for last, waiting for Christmas Day to actually put out my thoughts about this particular case. So hear me out if you're in the footwear industry. Now, footwears they also have elements of intellectual property such as the name Nike, the slogan "Just Do It," the design which could enjoy design right or design patent protection if it's in the US, because this is a US case, so let's say design patent, patent, etc., etc. Now, trademark as an IP protects the distinctive nature of an IP, which has been consistently used for commercial purpose. It also gives the owner the exclusive right to prevent third parties like that's KY from using Nike's lightning strike insignia and also promoting or copying or selling their design, just like how Cool Key and Omis were accused of. Turns out that they've had series of warnings from Nike's lawyers. Nike's lawyers had reached out to them of their alleged infringement sometime in August 2021. They also tried to settle but negotiation broke down. Then this year, 5th of October 2022, Nike's lawyer reached out to them again, telling them, you guys are infringing on our work again. Make una stop, told them they had 1 week. So this is where a cease and desist letter will come into play. But I guess because they had written several, the Omi Reloaded Merch and Cool K did not take it seriously, and they ended up being sued. Now, when one of the grounds for suing is an alleged infringer is false designation of origin under the United States Trademark Act, which is called the Lanham Act. What this means is that when a third party decides to use a trademark owner's mark, be it a name, logo, sign, symbol, insignia, with the aim to mislead consumers or the general public, or cause confusion amongst them as to its origin, it is an infringement. Whereas for trademark dilution, what happens is that the motive for that use is to harm or weaken Nike's Just Do It, or the design of their shoes. I already know that Nike is a well-known brand, it's a household name in the footwear industry. So you can imagine someone using your exact design, your exact insignia on their own footwear design. I came across a case this year. It was a black lightning kind of shoe. I didn't really dig much into it, but there was like a before and after. Like someone had previously done a design the previous year, and another designer took up that design too. I think he just faded the color a bit to make it seem different, but it wasn't. I mean, it was really obvious when people put it side by side. So that's something that happened here. Types of trademark dilution, because this is one one of the things that they were sued for. You have the blurring, which occurs when the use of a well-known mark such as Nike is used on another brand to reduce the quality. So it's like you buying a second hand, not a second hand, but a counterfeited, inauthentic version of Nike. I'm sure we've seen. Let me not even go into that. I was going to give an example of blurring scenarios we've seen. I have seen in Nigeria where someone put another brand's insignia or logo or name on the product. I'm trying to mislead the public, especially when it's a well-known product or well-known brand. Trying to reduce the quality or how unique the mark is known for in a particular class. Then you have tarnishment, which occurs when someone uses Nike's mark in a manner that is considered to be offensive or unflattering or could even harm the reputation of the brand. Then they were also alleged of unfair competition. Let me read that out for you guys as well. Unfair competition happens when someone deliberately uses illegal or deceptive or fraudulent ways to sell your product, thereby harm your consumers and also gain a competitive advantage. Now, example of this would be trying to take advantage of someone's achievement. Also, another instance would be when you do like a positive reference when you're comparing one goods to another, or you're misappropriating the person's goodwill, or you're criticizing the person's products and using unauthorized reference to your competitor, which is Nike. Now, how do you protect yourself from unfair competition? So, what are the intellectual property rights that exist in the footwear industry? One, you have design right for the protection of visual appearance of the footwear. That's how the footwear looks. It could be a combination of lines or colors that must meet the basic requirement of being new and novel. They have trademark for the distinctive name, logo, symbol, insignia that are consistently used for commercial purpose, like Nike have done. Then you have patent for the new functionality that can lead to a breakthrough in manufacturing of footwear. For instance, Michael Jackson had patented his anti-gravity illusion shoe. If you watch Thriller and some other of his musical videos where he's like bending down, you're like, oh my god, how did he do that? And then you tried it and then you fell. And you're like, I gotta keep trying and trying. But now the cat's out of the bag. So I posted a picture about that. Then you have copyright for sketches, documentaries, photos of the footwear, and finally trade secret and trade dress. Trade secret protects confidential information. Trade secret basically is kind of like design right, where it protects packaging, visual appearance, and all those things, but it's different, really different. Yeah. Then we also saw a lot of big brands entering the metaverse. So like I was saying, a lot of big brands are trooping into the metaverse to protect their virtual and digital goods, including NFTs, such as if we are following the Meta Beckins case, that's like that's a good example to show you why it's okay or advisable that brands should be proactive in protecting themselves. Then the Nigerian entertainment industry had its fair share of disputes which focused on ownership of musical works, unauthorized sampling. They had unauthorized sampling, unpaid royalties, getting credit to a song, e.g. the Carter F.A. Berry Tiga's Machala song, Asha filing a suit against Joe Boy and Tope. So one thing we need to know about this is that when it comes to musical works, as a recording artist, a songwriter, music producer, it's important that you document your creativity by signing split sheets and any other relevant document. A split sheet is a document basically that clearly states the percentage in terms of royalties to be shared between the collaborators and ensuring that their royalties are paid out fully and in a timely manner. And if you're in the creative industry or entertainment industry, copyright law applies to you as well as other laws. So you can explore the available legal backing and protection as provided by your territory. We're focusing on Nigeria and so Nigerian territory. Another Nigeria, the person that the first person who creates the work is known as the author. But in an event where you sign an agreement, it will state who owns the final work at the end of the day. Now, a co-owner of a copyrighted work is entitled to share joint interest in the whole or part of a copyright. However, when you waive that right in perpetuity throughout the universe, no court can actually save you. So be guided, review your contract with your lawyers. And also, as an intellectual property mechanism, a musical work enjoys automatic protection as long as it's in a fixed or tangible medium or format. It also protects the creation of musical composition and sound recording, master recording, and in a split sheet, the royalties are from the composition and not the masters. Producers are represented as composers, while songwriters are represented as authors. So if you really want to learn more about how copyright affects music, you can check out a couple of my podcasts. You can also do your research. You can also sign up for the Music Business Academy by Godwin Tom. Yeah, follow other music lawyers, entertainment lawyers, both internationally and nationally. Follow distribution companies, follow recording companies, follow a lot of entertainment related brands, so that you are in the know as to what's actually happening within your territory. Then we have the generative artificial gosh, a generative artificial intelligence. I think I need to drink water. A generative artificial intelligence copyrighted work that was revoked 20th, like 5 days to Christmas, by the United States Patent and Trademark Office after they had been granted copyright in a comic book titled Zara of the Dawn that used a text-to-image engine Mid-Journey and then they held that only humans are recognized as author, and that conversation has been ongoing for a while now. We also had the Dabble's AI case as well. We also have which I also put that case here as one of my top IP highlights for this year, which is the hold on which is the case. So, which is the case of Commissioner of Patent Australia against Taylor, 2022 FCA FC 62, where the Federal Court of Australia held that Taylor appeal and they said that only natural persons can be an inventor under the Patent Act. After Justice Beach had given judgment that AI can be named as an inventor and entitled to own an IP. So those conversations are still ongoing as to who can be listed an author, who can be called an author. Then you also have the case of Steven Tyler's work titled A Recent Entrance to Paradise was refused by the review board of the United States Copyright Office, stating that the machine is not capable of creating a work made for hire and that the registration was not supported by law and is unconstitutional. So this is still a growing area. I hope African countries are taking note of that and also trying to, get their data right, get the laws right, do the proper engagement so that we know whether we are updating our laws to include AI as inventors or IP owners or not. Then I think I have 2 more cases on my radar. Let me check. So the next highlight case for me would be the Kanye West and Adidas case over the implications of having a moral clause for artists, celebrities, influencers. I think the Kanye I won't call it a rant, but he made some anti-Semitic tweets and comments that people did not find funny, and then it was more or less like when They were calling for Jesus as like crucify him, crucify him. So this cancel culture that we have now, where if someone makes a comment that is not fine by a lot of people that they consider to be offensive, then everyone is calling for your head. Reminds me of the Uju case when Queen Elizabeth died and they reported her to her school, and they just came at her. So that's what basically happened to Kanye. And conversation as to having moral clause came up. Like, when do you trigger a moral clause? Should it just affect the brand, or should the person who is responsible for putting the brand in the limelight be held solely responsible, etc., etc.? And so I just thought about it. I was also going to do a tweet about it, but I was like, nah, let me save it for my highlight for this year, because it's very important that brands begin to take some of these things seriously. So if you engage or you present a talent, it's very important that you consider a morality clause, not just drafting a talent agreement or an endorsement or ambassador agreement or whatever relationship you're going into with the person, but try to include a moral clause. That way you can filter who can represent your brand or your company. Also, in a co-branding deal like we've seen, in Kanye West and Adidas relationship, is it co-branding or or partnership? I can't really tell, but issues as to intellectual property ownership will always arise, especially in the event of a dispute. That question will come up: who owns the rights to the intellectual property that was created within the course of the relationship? I mean, Kanye has been with them since 2013 and this is 2022. So that's about 9 years. So imagine how much they have created together. Was it properly stated that in the event that something happens, if someone defaults, does he forfeit the right to own the work he created while working with them, or collaborating with them, or partnering with them? Those are things that we need to consider. I know that morality clause are enforced once there's an agreement which will be binding on parties. It also gives a party the right to terminate the contract where the other party committed an act or engages in illegal activities that could hurt their reputation, just like Kanye West's easy breakup with Adidas. I think few days ago I saw a post that they didn't know what to do with Yeezy, the collection he had left with them. I think people are not really buying into it anymore, but I guess it's part of what happens. So what can brands do going forward to protect themselves? Make sure that the morality clause is not vague. You have to be very specific as to what is considered to be an illegal act, what you cannot engage in, what happens when you do that, what do you lose, who will be held responsible. You also need to make sure that there is no unequal bargaining power during the negotiation of the agreement. For instance, let's say let's use a scenario of a breach of confidentiality, which is trade secret. I own this confidential information, I'm giving it to you. If you divulge or tell a third party without pre-informing us, that could also hinder our relationship. Or the confidential information is shared with me, I give you say 5% of whatever it is that comes. Just make sure that the bargaining power is somewhat equal. Let it not seem like someone was coerced into doing anything. There should be no infringement of fundamental human rights such as right to privacy or freedom of expression. So if you clearly define all of that in your morality clause, it will give you a better strategy as to how to handle disputes or a breach that arises from the relationship. Now, in this area of social media and cancel culture, um, it was said that Yeezy, that's Kanye West, lost about $1 to $2 billion. That's a lot of money, guys. And influencer marketing and advertising guidelines on social media should be incorporated into businesses and brands. It's also important that brands or business have a checklist for intending parties that they want to work with. They also need to be free of scandal, need to be fit and proper. All of those things need to be taken into consideration. The kind of behavior that would trigger the morality clause, who handles PR, in the event of a scandal or controversy. How do you deal with your shareholders? How do you pacify your trustees, board of trustees? How do you pacify your consumers? So all of that should be put into place so that it seems like you're prepared. Not like anyone is going to relationships that it turns out to be bad, but then you can't really predict the future. So I hope a lot of brands learned from what happened to Kanye and Adidas and position themselves going forward in 2023, that they're able to um, avoid all of these things. Last but not the least, top IP highlight for me this year was the case bordering on the protection of well-known marks in Nigeria. It's the Fan Milk International against Mandarin Oriental Services and the Registrar of Trademark. Now, what is a well-known mark? We already know what trademark is. A trademark protects distinctive marks that act as a source identifier or lets consumers identify or link a product or goods to services to the brand in question, so far as they are unique and they have consistently used it for commercial purpose. So this case, I mean, it didn't really go viral, but I feel a lot of people should take it, especially when you get like a cease and desist letter from a well-known brand that is abroad and coming into Nigeria to try to enforce their rights. It's a bit technical when they haven't registered in Nigeria, in as much as well-known brands are supposed to enjoy protection based on the reputation and goodwill they have. But this case, in the court's with the wisdom, it's like the only principle we have for now, hoping that things would change. But to take us through the steps, a well-known mark is considered to be one that is recognized as something that's popular, either according to the courts or the trademark registry. And it gives you like the strongest protection, especially like you're being backed by the court and the trademark registry, that okay, this is a well-known mark, um and you get to enjoy all the benefits of being not just a trademark but being well known, being famous in that jurisdiction or in certain jurisdiction, because IP only protects works that are registered in that territory because of the territorial nature of protecting your trademark. It also give you the benefit of enjoying IP protection, which must be well known to a relevant section of the public. According to the TRIPS agreement, this can be according to the TRIPS agreement, this can be triggered when the use would or can be linked to indicate or connect to the owner, connected to the owner. It might even cause damage as a result of that. Now, well-known marks can also be protected against a confusingly similar trademark, also known as conflicting marks, that may its act may be considered to be an infringement of the trademark owner. And when I mentioned TRIPS is an acronym for the trade-related aspect of intellectual property rights agreement. So when I just say TRIPS agreement, just know that's what I'm talking about. Now, a brief summary about this case. Turns out that Fan Milk, I'm pretty sure most of you know Fan Milk, they do the dairy product as their ice cream. In the square shape, that's I don't know what size shape size to call that, but you see all these ice cream bicycle guys riding with it and selling fan milk. So yeah, so if you look at the product himself, there's like a logo in form of a fan and then Fan Milk under it. So Fan Milk, a company that produces and sells frozen dairy products, owns the fan and device marks in class 29, in class 30, Class 29 again and class 30. So let me just read what class 29 protects. So class 29 is for meat, fruits, milk, and oil meat extract, preserved, dried, and cooked fruits and vegetables, jellies, jam, compotes, eggs, milk, and milk products, edible oils and fats, prepared meals, soups, and potato chips. Then class 30 is for coffee, tea, cocoa, sugar, rice, tapioca, shago. I think that's how it's pronounced. Artificial coffee, flour, and preparations made from cereals, bread, pastry, confectionery, ices, honey, treacles, yeast, baking powder, salt, mustard, vinegar, sauces, condiments, spices, eyes. Oh my god. Okay, that's just an inner joke, but let me carry on. Sandwiches, prepared meals, pizza, pies, and pasta dishes. So they already have a trademark registration for this. Now, unfortunately, they do not have trademark protection in these classes in Nigeria, and they went ahead to oppose Mandarin's trademark application for its fan device in class 9, which is for insurance, financial services, real estate agency services, building society services, banking, stockbroking, financial services provided via the internet, issuing of tokens of values about bonus and loyalty schemes, provision of financial information, and in class 43 for services, providing foods and drink temporary accommodation, restaurants, bar and catering services, providing of holiday accommodation, booking and reservation services for restaurants and holiday accommodation, retirement homes and schemes. Retirement home services, crèche services, and they were relying on the fact that they already have a trademark in Africa, some part of Africa, not the whole of Africa, because Nigeria is part of Africa and they do not have a trademark in Africa. In Nigeria, which is an African country, Asia, Europe, and the Middle East, because as we know, IP is territorial and only protects and grants legal backing and protection where the trademark is registered. So you can imagine where the confusion is coming, or why the courts told the line that they did. And they're saying that Mandarin's application would cause confusion and infringe on their well-known mark. So my questions were bordered on what constitutes intention to register the mark. They stated they had the intention to register in Nigeria, but they hadn't begun to do that. So what constitutes intention to register a mark? So when an application is made by the person who wishes to apply for a trademark, and the person has consistently used the mark in relation to the goods, they must show proof of documentation at the time of filing. So if Fan Milk wanted to actually apply, or say they had intention to register a mark, they must show the trademark registry that they have consistently used Fan Milk fan device for commercial purpose. Proof. How have you used it for commercial purpose? And Farming is not a small brand though. They've been in business for years, way before Mandarin Oriental Hotel came. When a trademark application is to register a device mark, it represents the mark in any form, such as a logo or words, as long as it meets the criteria of being distinctive and can act as a source identifier. So if you put the marks side by side, can you state, oh, if I see this is for Fan Milk, or if I say this is for Mandarin? I never knew what Mandarin Oriental hotel logo was like until this case, so it was really eye-opening for me. Well, trademark violation, because they sued them or for trademark violation as well, trademark infringement. So trademark infringement is basically a violation of the exclusive right accorded to a trademark owner to use in relation to the goods or services. Not section 5. It's up to okay, I'm quoting section again, but just hear me out, guys. So section 5 sub 2 of the Nigerian Trademark Act lists the acts that can be considered to be an infringement, which is 1, where the mark is likely to deceive or cause confusion. 2, where there's an unauthorized use of the offending trademark, and where the all unauthorized use of the offending trademark is identical to the one registered. So we already know that when you don't get consent, permission, authorization from the IP owner or trademark owner, as it is in this case now, that is considered to be an unauthorized use, also a trademark infringement and violation of the trademark owner's exclusive right. So if you do all of these things, then you can be sued for trademark infringement. So I had done a poll asking if anyone saw any essential features of the fan milk, fan, and device mark, and if they could say that it was a clear copy of the Mandarin Hotel. That is, if the Mandarin Hotel was a clear copy of fan milk's design. 40% said yes, 20 said no. 40% said can't decide, but I didn't really get much vote, so it's a bit tricky for me. But if you put it side by side, I think there are differences. They're both fans, so maybe that would count. And then the way the word was positioned directly under the fan, I think the only difference would be that for fan we could put the word fan in the in their insignia, whereas the Mandarin one was just there. So if you can check out the Twitter version to look at it better, or just do a Google search to find out what it looks like. Fan Milk in their argument had stated that under the trade-related aspect of intellectual property rights agreement, that is the TRIPS agreement, their mark was valid and existing in Nigeria and also protected under Article 6B of the Paris Convention. So the Paris Convention is a treaty that's an IP treaty that protects or applies to patent, trademark, industrial design, utility model, service mark, trade names, geographical indication, and also the repression of unfair competition. It also helps creators ensure that their intellectual property rights are created in the member states, countries, or contracting parties or contracting states. Now, luckily, Nigeria is a member of the contracting party to the Nigeria has been a contracting party to the Paris Convention since September 2nd, 1963. A lot of history there, guys. But then they were stating that they are a well-known brand in and out of Nigeria. Now, the Federal High Court, in its wisdom, after hearing parties' arguments, decided that both trademarks, that is the fan milk trademark and the Mandarin trademark, were not identical or even likely to deceive the public or even cause confusion. Because another criteria for trademark infringement is that you must show that the customers are confusing the Mandarin trademark logo for the fan milk logo. So if you put it side by side, and all of these things, and the court further in Sweden decided that, and fan milk has been around for a long period of time. Consumers were already familiar with what the fan milk logo looks like, which was boldly written under the blades. On the issue of whether fan milk can claim rights over an alleged confusing trademark, the court relied on section I don't know why I always laugh when I'm citing sections. Oh, I can't help it, guys. Please bear with me. The court relied on section 13 sub 1, which talks about the general rule of exclusivity over the use of a registered trademark and the protection granted to the owner of a registered trademark in line with our acts. Now, if you are interested in trademark, check out the MacMuddy's what's it called now? Let me get it. So it's called the Commentaries and Analysis on Nigeria's Trademark Act by MacMuddy SAN. It's a very insightful book. So each of the section has been dissected, and he has shared his comment as to giving you a better explanation. So when you're reading this section, you're able to understand each of it. It's helped me a lot in most of my researches. It's one of the books I also rely on, and also the trademark Understanding Trademark Law in Nigeria by Isaac Oba, which was a gift to me from Mr. Franklin Ye Lerum. Thank you so much, sirs. I got both of these books as a gift, but yeah, I'm digressing right now. So let me continue. So McMurdo in his book listed the basis of a trademark opposition against a prospective applicator. Now, you can check that out. I don't know if you guys would like me to read it for you. I would have, but you can check the sections that talk about opposition. Hold on. Now, in a trademark opposition, this is one of the bases for protecting the exclusivity of a trademark registered prior in time by placing them in the public domain through the trademark journal prospective marks that have been accepted. So you can check out more information on that in Max Mordy's book. You can also look at duties of the opposing party. That is fan milk in this instance. Now they have the right to challenge the registration of Mandarin within the time set out by the Trademark Act and accompanied by their statutory declaration, written agreements, and appearing at any hearing set by the registrar to argue their opposition. So they had done that already, and the trademark registrar said this mark is not similar to yours, and you can appeal a trademark opposition. After your appeal will be to the Federal High Court, so which is what they did. Now the Federal High Court also decided that if Mandarin fan device was identical, the trademark registry could have rejected the application, which is true. But they never did. So fan milk were not entitled to any claim. And finally, in line with Section 12 of the Constitution of the Federal Republic of Nigeria. Hold on, guys. So what says that that section oh, hold on, apologies, that section prevents fan milk from claiming the benefit accorded to famous and renowned marks like fan milk who has been in existence for a very long time. Now section 12 reads as follows. For those that will not be able to Google it, let me just help you. Let me just help you guys. Yeah. So Section 12 reads that no treaty between the Federation and any country shall have the force of law to the extent to which any such treaty has been enacted into law by the National Assembly. So just because of that section, fan milk lost their right to being recognized as a well-known mark. And since Nigeria is yet to domesticate the Paris Convention, which provides right of priority for patent, trademark, design rights, service mark, etc., etc., they also cannot do that. Now, during opposition, it's very important that you provide the registrar with credible evidence to show that the mark that is in this case now Mandarin wants to register is not distinct, does not meet the distinctiveness test, and is identical and confusingly similar to a prior trademark application, which in this case would be your application. So those are the basics of trademark application. So if you're a trademark agent or a lawyer, or you have an interest in registering trademark, please make sure that you read the Trademark Act to be properly guided. For lawyers too who represent clients, make sure you properly advise them as well. I used to have this perception that well-known marks could be enforced in Nigeria, but judging by this case now, I don't think that is the case. Because I mean, if you look at, I know there are cases like the Yeezy case. I think it was in China, or I think it's one of these Asian cities. Anyways, he was able to get his trademark back from whoever it was that was attempting to take advantage of the reputation and goodwill that his mark already had in the market. Yeah, so those are the issues. Just I don't know, but I think I'm done. I think I'm done, oh guys. I think I'm done for this year. I think I'm done for this year's 2022 IP highlight. Let me know what you guys think about these cases. So we've come to the end of our top IP highlights Christmas edition for 2022. Looking forward to what 2023 has to offer. I'm also looking forward to analyzing more cases and doing a bit more newsletter writing. So if there's a case that I've reviewed so far and you want me to give you the newsletter version, please let me know. But yeah, stay tuned for our next episode, which will be the last episode for 2022. I have a very interesting guest that will be coming on my podcast to talk about a very interesting topic. But yeah, thank you so much for listening. See you in the next episode. Bye guys.